Got it. Let's go.
Okay, I'm going to go ahead and call to order this meeting of the November 21st, 2019 Nashua City Planning Board. Mr. Secretary, can you go ahead and call the roll?
Yes. Mayor Donches. Mike Peterson.
Present.
Scott Leclerc.
Here.
Adam Varley.
Here.
Edward Weber. Here. Alderman David Tenza. Alderman Marianne Mazzilli-Goya. Jerry Rupucci. Maggie Harper.
Present.
Bob Bollinger.
Here.
Okay, so we have 6 regular members here, so we have a quorum to go ahead and start. So in front of us, we have the November 7th, 2019 Planning Board minutes. Has anybody had a chance to take a look at those and want to make a motion as to whether they are acceptable as presented or need to be amended? Mr. Bollinger?
Mr. Chair, I'd like to make a motion to accept the minutes.
Okay, so we have a motion to accept by Mr. Bollinger. Do we have a second? Second by Mr. Peterson. Any discussion? All those in favor?
Aye.
Aye. All those opposed? Abstentions? 1. Ms. Harper? Okay, so that motion passes. Okay, communications.
Yes, good evening, Mr. Chairman and members of the Planning Board. Tonight you will find in your packets the following correspondences. Amended Planning Board agenda for November 21st, 2019. And from the City of Nashua, Sarah Marchant, Community Development Director. Correspondence, funding source for NRPC to complete a pedestrian and bicycle transportation study. Next item will be a memorandum from Donna Graham, Legislative Affairs Manager, concerning the establishment of a committee to draft the master plan. Next item will correspond to Case 1, and that will be the Zoning Board's decision on November 18th, 2019. And the final item for Case 3 from the Flatley Company, tabling case number 3 till May 21st, 2020.
Okay. Thanks. Report of Chairman, Committee, and Liaison?
We had no applicants.
Okay, so, all right, so moving on. Old business. Before I move on, I'll go ahead and read the procedure of the meetings and hearings for anybody who's here in the audience. So the procedure of the meeting and hearings are as follows. After each legal notice of conditional special use permit, site plan, or subdivision is read by myself, the board will determine if the application is complete and ready for us to take jurisdiction. If we do take jurisdiction, the public hearing will begin, at which time the applicant or their representative will be given time to present an overview and description of their project. They'll speak to whether or not they agree to the recommended staff stipulations, and the board will then have an opportunity to ask relevant follow-up questions of the applicant or staff. I'll then ask for testimony from the audience. First, I'll ask for anybody wishing to speak in opposition or concern to the plan to come forward. If you decide you'd like to do that, please go ahead and come to the microphone, state your name and address for the record. This is the time for you to express any concerns or ask any questions you may have regarding the plan. Next, I'll ask for testimony for anyone wishing to speak in favor of the plan. The board will then ask any relevant follow-up questions of the applicant. The applicant will then be given a rebuttal period, at which time they'll respond to any of the concerns raised by the public testimony. If needed, I will allow one member of the public to come forward again and respond only to those items brought forth during the applicant's rebuttal period. I will give you time to get together if necessary before that and elect someone to do that for you. After this is completed, the public hearing will end and the board will resume a public meeting, at which time we'll deliberate and vote on the application before us. I'd ask that both sides keep their remarks to the subject at hand and to not repeat what has already been said. I want to be fair to everybody and make the best possible decision based on the testimony presented and considering all applicable approval criteria established in the Nashua revised ordinances for conditional special use permits, site plans, and subdivision plans. I thank everybody for their interest and courteous attention, and ask if you do have a cell phone, please go ahead and turn it off or put it on vibrate at this time. Mary Ann, come on up. Yeah. So Ed, can you make sure you get Alderman Melissa Goya as well?
You're at the head of the table.
Yep, you're right at the front here.
Oh, there you are.
Thanks.
Okay.
Yes.
Okay, so moving on to old business conditional special use permits, there are none. Old business subdivision plans, there are none. Old business site plan, case number 1, Linistas Family Trust, Ally Bird applicant, proposed dog daycare and boarding facility. This property is located at 1 Hardy Street. And this item was tabled from our October 17th, 2019 meeting. So at this point, for the board folks to go forward with this at all, we need a motion to remove it from the table. And then I can reopen the hearing. I remind everybody, when we did table this, we specifically, the motion by Mr. Barley at that time was the table for the purpose of clarification from the zoning administrator regarding scope relief from the ZBA, which we did get some information in our packet on that. And that was kind of regarding an outdoor display area and the use of a variance, and for the applicant's engineer to do due diligence regarding abutting deeds and lot lines. Okay. So just a reminder of that. So, does anybody would like to make a motion as to whether to remove this from the table? Mr. Barley?
Mr. Chairman, I would make a motion to remove this item from the table for the purpose of hearing from the parties on those specific issues you mentioned.
Okay, so we have a motion to remove from the table. Do we have a second on that? Second by Alderman Melissa Goya. Any further discussion? Mr. Ballinger?
Mr. Chair, is it worthwhile to ask for clarification from staff with regard to the 2 correspondences which were contained in our packet, or should we address those if necessary throughout the hearing?
Typically, we would do that during the meeting, I think, or we could do it during the hearing, either one of them, but I think it's okay to open and have that discussion during that.
Very good. Thank you, Mr. Chair.
Yeah. Any further discussion? All those in favor?
Aye.
Opposed? None, that motion passes. Okay, and do we need a motion to open the hearing?
We did last time.
I think so, right?
Did we close the hearing?
We tabled it. I don't think it hurts to make a motion to open it.
I'll Mr. Chairman, I'll make a clarifying motion to the extent necessary that we reopen the public hearing.
All right, so we have that motion to open the hearing. Do we have a second on that? Second by Mr.
Second.
Ballinger. Any further discussion? All those in favor?
Aye.
Okay, that motion passes. Okay. So a reminder, we had a couple of things that we had questions on during the table, that being the ZBA review and particularly any information regarding abutting deeds and lot lines. So,
Sure.
thanks.
Good evening, Mr. Chairman, members of the board. For the record, my name is Chad Brannon. I'm a civil engineer with Fieldstone Land Consultants. Our office is located at 206 Elm Street in Milford, New Hampshire, and I will be representing Ally Bird this evening with the continued discussion of her site plan application. As you stated, Mr. Chairman, we were before you last on October 17th, and the meeting, as I understand it, concluded with some questions pertaining to some zoning interpretations, and then also some questions relating actually kind of directly to the abutting, potentially the abutting ownership along the north side of the property, and a particular 2-foot strip of land that might be on the south side of Amherst Terrace. So I guess just to start with the zoning board components, we did attend the zoning board hearing. I believe the hearing might have been on November 12th. And at that hearing, the zoning board of adjustment decided that section 19052 of the ordinance pertaining to outdoor storage should not apply to a dog daycare use. And as such, all of the items that I believe this board was concerned about pertaining to potential setbacks to a display area, potential impervious surfaces required for a display area, all of those items are no longer applicable to this application because it's no longer considered a display area. With that said, we did actually perform some research on the abutting roadway. We certainly didn't know how the ZBA hearing was going to go, so we wanted to be prepared. So we had surveyors at our office conduct a significant amount of research. This consisted of contacting the city engineering department in order to pursue additional information for Terrace Avenue. The city surveyor did eventually recover a terrace dated March 4th of 1928, which does and did depict a 2-foot wide strip directly adjacent to the back of One Hardy Street, which is our property, and also along the east side of Amherst Terrace, which would seem to support the abutter's claims that he represented at the last meeting. It is important to note that this plan is only located at the city engineer's office, is not stamped, and is not a recorded plan. With that said, unfortunately, the city surveyor, and with our help in researching, we were not able to find any documentation related to Amherst Terrace and the city adopting Amherst Terrace. So although we couldn't find anything contesting the abutters' claims, we also couldn't find anything of substantial evidence, I would say, supporting it. So the results are inconclusive. We did also perform a registry chain of title and a right-of-way plan search on the lot in question, which is 1 Amherst Terrace, back to when it was first subdivided from the Shea lot, which is what the property was called prior to the subdivision and creation of Amherst Terrace. There was evidence of the 2-foot strip being referenced in deeds all the way back to the conveyance or the creation of the property. But typically when cities cities or towns take over a property or roadways, and they accept roadways, they normally don't allow for strips of lands to occur, and we oftentimes see them being amalgamated into the right-of-way. But we can't support it one way or another at this point. When the Zoning Board of Adjustment ruled that that this was not a display area, we actually stopped our research efforts because this can actually become quite cumbersome going back in time. We would have to research all of the meeting minutes in that era to try to get some data on, what the terminology was when it was potentially adopted, or try to continue researching at the city engineering office, and I know that they worked hard with us to try to find the documents. So when the zoning board ultimately ruled that this section didn't apply, we chose to stop essentially the research efforts. With that said, what I want to point out is if we found evidence that would support this 2-foot swath, it would turn the setback actually into a side setback rather than a front setback. So we decided to leave the plan as a front setback, just to err on the side of caution. But there is no requirement for setbacks to any usage of the lawn area in the backyard. So I share all this information to try not to create any more confusion. If you recall, the setback only pertained to a classification of it being a display area. Since that no longer applies to the dog daycare use, there is no setback, there is no violation, there is no issues with the site plan that we have before you this evening. So with that said, Mr. Chairman, I believe those were the two items that the board had concern over and wanted additional clarification on. I do believe there was a waiver request that we talked about at the last meeting, and I don't recall or see in the minutes that that was ever voted on. And we do not have any objections to any of the staff comments. So that would be happy to try to answer any questions that the board may have.
So if the 2-foot strip along Amherst Terrace on the south side there was indeed part of the neighbor's lot or whatever, is there anything in the current plan or existing that's essentially on that? Like there's a fence there, right?
There is not, the fence and everything is on our property.
It's inboard of the 2 feet.
That's correct.
Okay. All right.
And that's supported on the plan that's before you. We show the monumentation that we located, the property boundary that we located. Everything is represented correctly on this plan as it pertains to our property. The problem is there's no evidence to support the swath other than the notation of it in the deed. And there's no evidence to discount it. For example, the city doesn't acknowledge that as a separate parcel on any of their maps. Technically, if there was a swath there, that would be a separate tax map parcel. And so there is nothing that would cause attention or create some attention to that matter. But there's nothing in violation. There's no setback issues, from there potentially being a 2-foot swath of land adjacent to our piece rather than it being the road.
Okay, so to clarify, the 2-foot swath we're talking about on your plan, I can't see the number, sorry, it's too small for me, but your site plan, it's currently on your plan represented as roadway.
Absolutely.
It's not.
Which is consistent with all of the city maps. Even the city maps, the utility maps for Amherst Terrace do not show a 2-foot swath of land.
Right.
There's one map that shows it, there's many maps that don't. It's referenced in a deed. Normally, you would find this information, in the language, when the city accepts the road, it calls out the dimensions of the right-of-way. And what we would be able to do if that document was found is we can recreate the lot, we can recreate the right-of-way, we can tie everything together, and we can tell mathematically where everything lies.
Yeah.
But that information really isn't relevant to this site plan because whether that swath exists or not doesn't change the proposal that we have before you. We're not proposing anything that would be, out of compliance if there was a 2-foot swath on the north side of that line.
I was really mostly trying to clarify, if I'm looking at this plan, can you, just for everyone's sake, can you outline where that 2-foot would be?
Sure.
Just on there, so we know.
Want to take the mic if you.
Yep.
So
You
if-
don't have to do it to scale, obviously,
Yeah.
but like where would it be? I wanna.
So it actually would exist on this south side of Amherst Terrace. This is the right-of-way line
Okay.
right here, or what we believe to be the right-of-way line.
Yeah.
That would be the common boundary between our property and the property to the north.
And the
So
2-foot
that's either a right-of-way or it's the 2-foot swath.
Got it.
So that would exist in common with our property between this bound that was found at the intersection of Amherst Terrace and Amherst Street,
Yeah.
and this bound that was found between parcel 62-150 and the subject parcel, which is
But it
62-152.
would be in the direction of the middle of the street.
Right, it would go out 2 feet. I mean,
Got it.
the width of that line shown on the
Sure,
plan is
yeah,
about a foot.
I get it, yeah. Okay. Okay. Other questions of the applicant by other members of the board? Mr. Peterson?
I have one question for staff and 3 for the applicant. Shall I proceed?
Yep, go ahead, yep.
My first question is for the staff. Are you in agreement that there's no need for setbacks for this particular business with the backyard neighbor? You know, the people at the, I don't know what you call it, the bottom left of the picture of that backyard neighbor, there's a fence, and is there a setback needed to conduct this business there,
No,
in your opinion?
based on the rehearing that went before the zoning board, they felt that this storage, which is the 19052, did not apply, so there would be no setback required. There are no setbacks for fences, so they would be in compliance.
Okay, so you're in agreement with the applicant about, and the board, the zoning board, on the setbacks?
Correct.
Okay. Question number 2 is, so could you please describe your final plan for the fencing? Like, I noticed the current fence has got, you know, openings, and it's not very high and all that, so could you please describe what your final fence will look like?
Sure. Well, we're proposing the same fence that's there. It's a wooden stockade fence. It is 6 feet high. It does have a kind of a shape to it where it's slightly lower than 6 feet in the middle, so it has like an architectural appearance to it. And I do have photos of that if you'd like me to hand that around. But we're only proposing very small sections of new fencing here, and it's actually referenced on the plan before you in red. So there's existing fencing along Amherst Terrace here, and then there's an opening on the north side of what is a carport. We would be closing that opening off, which is the red line there. Then we would utilize the existing fencing all the way along Amherst Terrace, then along Amherst Street, and then that actually comes back and ties into the house. So that's all closed off through here. And then we're proposing fencing basically between the 3 structures. So you have fencing here, and then you would have fencing there, and that would create an entire enclosure. Same materials, same fencing. It's actually a very nice fence. And if I may, Mr. Chairman, I'd be happy to hand out some photos of that.
Sure, that'd be great, yep. Just, you can pass it to Mr. Peterson, and we can just kind of send it around, and then, are they copies that we can,
You may keep these.
okay, so we'll give them to staff after, yeah?
Okay, I have another question.
Sure.
So who is the current owner of the property in question? And if it's for sale, who will be the final owner when the business starts?
M-
I guess I'm talking about whatever this address is. I don't see it right here.
Sure. So the current owner is David and Stephen Lanastis, trustees of the Lanastis Family Trust. And the owner, you know, assuming that we obtain approval on the property, would be Ally Bird. I don't know what entity she may own that in, but she plans on residing in the house and then running the business on the property.
Okay, so currently not owned by the applicant.
Correct.
Okay. My other question is, what is the plan for picking up and dropping off the dogs for the daycare center? I mean, I noticed on both sides of the property, it's a two-way street, so cars could come from all kinds of directions. I'm just wondering if the clients, you know, the dog owners will have guidance as to how to approach in the morning and where to drop their dogs off and how to exit, so it's not a big traffic jam out there.
Absolutely. So the project requires one parking space, and there's going to be formally 2 spaces in front of the building. One of them is a handicap space, so there's a fair amount of room there. And it doesn't take very long at all for, the drop-offs. A lot of times, Miss Bird will actually come out and accept the animal or the dog outside. Sometimes the people will bring it in, but she doesn't have any issues currently where she operates her business with drop-offs, and we anticipate this location has actually a lot more space for the drop-offs to occur, because not only is there 2 formal spaces, but there's room technically to park in tandem if you had to on the property. And so we're not proposing any parking off-site. People would back out of the parking spaces onto Hardy Street and then exit onto Amherst Street. But there's definitely plenty of room for the operations, and the site does meet all the city guidelines and design requirements. I'm just going to hand these photos
Why
out.
don't you grab those?
So
and
just
cut-
as a follow-up, so when you say in front, you mean the Hardy Street side of the building? When you say the drop-off in front?
Yes, there's a parking lot in front of the proposed building that we're proposing to operate the business out of. And so that would be the Hardy Street side.
Okay, thank you very much.
No problem.
Other questions for the applicant or staff from the board? None at this time? Okay. All right, at this time, I'll open the floor to anybody wishing to speak in opposition or concern to the plan. I'd kind of remind you that we're open for discussions regarding the zoning and the deed and the lot. It's not really about configuration and architecture and surfaces and things like that. That was talked about in the last meeting, so, thanks. And make sure you state your name and address for the record, thanks.
Hi, Clayton Alexander, 1 Amherst Terrace. First off, about the deeds, he's saying the results are inconclusive. I disagree with that. All the evidence is on the deed itself. The deed is the legally controlling document. And as far as a right-of-way, a right-of-way doesn't affect the property line. I mean, the property line is where the deed says it is. He also mentioned the GIS and tax map, and I want to point out that we've actually discussed this with the city before. There's been a dispute with the previous owner. He had where the port is, the carport is. He opened up that section of the fence and was parking and exiting over our 2-foot strip of property. So we had called code enforcement and talked to other people at the city. And the GIS map has a disclaimer on it that it is not a legally binding description. And we also talked to somebody in the GIS department. It doesn't show that 2-foot strip because they consider it too small to tax. So that's the only reason why it's not on the map. But according to the deeds, everyone on Amherst Terrace, owns that 2-foot strip. And somebody at the city that we had talked to had pointed out that the very reason it's called a terrace and not a street was because that 2-foot strip was meant to provide a buffer to the adjoining street. So just to clarify that. So the ZBA denied our request for rehearing. We think their decision was illegal and unreasonable, and we're appealing that to Superior Court. I've asked repeatedly for clarification from the Planning Department about the applicability of 19052 to the site plan. I haven't received any. I don't have enough information to know how to respond here. I've reasonably relied on the city's representation so far, but I'm not sure if they're correct or complete. For the record, I object since this violates my due process rights. and I will also throw in municipal estoppel as well. What Mr. Brandon said about the ZBA was a mischaracterization. I don't think, they didn't actually rule that 19052 was not applicable. The ZBA left this up to the board to decide. Carter Falk said at the rehearing meeting, quote, "The planning board can deal with all those A through J issues on that 19052 section, and they can go over all those because that's proper in their site plan review. It wouldn't be a zoning board issue." So I think it's up to you guys to decide whether it's applicable or not. And I don't think there's any reason why you shouldn't decide to apply the ordinance requirements. Under the city's zoning regime, if a principal or accessory use isn't specifically permitted, it's prohibited. My argument is that there really isn't any ordinance permitting an outdoor dog area, even under the use matrix, but that's ultimately a question for the court to decide. Even if it's a permitted use, for purposes of the site plan, 19052 is the closest thing to a relevant regulation. You've already accepted jurisdiction for this application. It was allowed to move forward based on the variance under the ordinance. The precedent here is that the same ordinance has already been applied to Chewy's Playland dog daycare and now to this dog daycare. The interpretation and application of the ordinance must be consistent. It's a contradiction to apply it to Chewy's Playland, but not here. The attorney who filed the other motion for rehearing on this matter said that the variance remains valid. The ZBA has not formally vacated it, and the only thing they did at the motion for rehearing is deny our request. So arguably, the variance is still legally operative. The ZBA only said that the variance wasn't needed in the first place. So in any case, the outdoor dog area has been considered to be an outdoor display area under the ordinance. The ZBA hasn't granted any additional relief from applying 19052 to the site plan. A variance doesn't exempt the applicant from any provision not specifically ruled on by the ZBA. And regardless of the variance, any ZBA decision only relates to the property use. It has nothing to do with the site plan. Another ordinance, 190-146, says, quote, "The site plan shall comply with all applicable requirements of Part 2, which includes 19052. Section A of 19052 says the ordinance applies to a site plan. Quote, "Outdoor display is a permitted accessory use if expressly permitted pursuant to a site plan." Sections A through J further specify site plan requirements. So no other variances or waivers have been granted, so I think all these sections should apply. This is an outdoor area for 10 to 20 barking, rowdy dogs, taking 3 to 4 potty breaks a day, and who knows how many more with the overnight boarding. I'm not sure how many dogs, since the applicant keeps changing the story. You should regulate and restrict the outdoor area and make stipulations to the fullest extent of the board's authority. Requirements under 19052 for confining the area to the lot of principal business use, a 20-foot setback, an all-weather hard surface, and a visual and physical buffer from adjoining residences are perfectly reasonable and necessary. Stipulations for waste management and disposal, noise control, and limiting the number of dogs are reasonable and necessary. The urban chicken ordinance has similar and even greater restrictions on outdoor areas. I don't think it was even permitted to keep chickens outdoors until that ordinance was recently passed. It's unreasonable not to have similar regulations for dogs. You have the authority to consider the effects on health, safety, nuisance, property values, aesthetics, and public health concerns. The area must be able to coexist and shall not have significant impact on surrounding uses or significant health and safety impacts on surrounding properties. This site plan raises all of the above concerns. I think the two lots are really the most important issue here. The outdoor area must be located on the same lot as the principal business use according to 19052F. The outdoor area is incidental to the principal business use on the lot with the commercial building. The other lot is only being used residentially, as the site plan states. The staff report states. The ordinance isn't the only thing confining the outdoor area to the business lot. Irrespective of the ordinance, okay, the ZBA decided that the variance wasn't needed in the first place. So even if an outdoor area in general might be permitted under the use matrix, there is nothing whatsoever permitting the use of the residential lot for the area location. The Hardy Street deed says it's on 2 lots. The original variances granted in 1983 and 1987 clearly state that the property consists of 2 adjoining lots of land. These earlier variances were granted only in respect to the 1 non-residential lot of land and only allowed use for the 1 commercial building. Nothing else permits this outdoor area for commercial use to be located on the residential lot where it is on the site plan. It just won't fit on the business lot. So I think it's both legally and physically impossible to construct this area as proposed. That should be the end of it. The applicant said that she would abide by a 75 square foot per dog industry standard. The backyard and the building are simply too small for this. I'm also asking the board to stipulate limitations on the hours of operation because it creates adverse impacts on the neighborhood. Barking rowdy dogs from 7 a.m. to 7 p.m. 5 days a week, plus ongoing overnight boarding, is completely unreasonable. Another local dog daycare only allows dogs outside from 9 a.m. to 4 p.m. to avoid too much noise disturbance. As far as this map, I mean, it looks like the exact same map that was presented last time. The property lines still aren't correct. I don't think anything the zoning board said about the outdoor, whether this is an outdoor display area or not, has anything to do with the requirement that the correct property lines and lot lines and the uses of the lots be shown on this map. And there's also there's vegetation along the back fence there that isn't shown on here either. So, on that basis, I think the requested waiver of 279 EE should be denied. The applicant still hasn't done due diligence. I've already had to point out several errors, and I can't review and respond to any additional errors. I also just quickly want to say something about the noise levels, if you'll let me.
I think brief, because we get the
Okay.
point that you've made that a couple of times, including the
Yeah,
last.
I just want to say, I have an article from Dog Daycare and Boarding Magazine. It says, a single dog barking is 80 to 90 decibels. With a group of dogs, it can reach 115 decibels. OSHA requirements requires hearing protection at 85 decibels. Normal human speech is 60 decibels. An automobile is 80. A jackhammer is 90. Louder than 85 decibels, hearing damage can occur. All sorts of negative health effects. This article suggests acoustic treatment for the interior of the building. I'm concerned about the interior of the building particularly. The soundproofing is totally inadequate. The building has it's a converted garage with a large plate glass window in front. There's no acoustic insulation whatsoever. The applicant applied at 158 Amherst Street, and that plan included soundproofing. So, and, as far as the outside noise, I guess earplugs are the only solution. And, even the dead in Edgewood Cemetery aren't going to be able to rest in peace. Just a couple things. Mr. Peterson had asked last time about the Wizzy Wash disinfectant.
I'm going
wasn't
to
a-
have to kind of cut you off.
Okay.
Those are, you're repeating
Yeah,
the stuff that you said the last
Okay.
time, and it's really
I just want
not
to tell you, I
helping
have
us
the
make
materials safety
decisions.
data sheet on that, and
So-
there's a lot of risks. And there's also some new artificial turf issues that have come up that Mr. Peterson had asked, and so I thought he may be interested in that, but I'll
Okay.
see that.
Did you want to see that?
I would be interested to see that, yes, I would.
Yeah, you can go ahead.
Okay.
and Send it up there.
Yeah, here's the safety data sheet. And the artificial turf, you had asked about the installation of it. The applicant, where she's currently running her business illegally out of a house at 5 Indiana Drive.
Again, you're just repeating exactly what you
Okay.
said the last time, so I'm kind of running out of patience.
Well, okay, all right.
All right.
But
Appreciate it.
there's a safety data sheet that should be in the plan, and the installation requires nailer board, stainless steel, rebar, and stuff like that, which there needs to be turf instead of grass. That's what I'm saying. Thanks.
Thanks.
May I ask one question of the applicant?
Sure.
So,
That's not the applicant, but yeah.
yeah, well, in your understanding, the dogs will not be in the house, they'll be in that one-story structure with the big plate glass windows?
Yeah, well, we've been told the house is going to be used residentially, so the boarding is going to take place in that converted garage with the big plate glass window. Now, I don't know if she's going to let dogs come into the house. I don't think that would be a permitted use. But yeah, as far as we've been told, it's just going to be the residential backyard and the converted two-car garage that was converted into office space.
Thanks. Yep. Anybody else wishing to speak in opposition or concern with the plan or questions with the plan? Anybody wishing to speak in favor of the plan? Come on up, please state your name and address.
I'm Colleen Bird, I'm Ally's mom.
Okay.
I just
Excuse
wanted
me,
to just make
excuse me.
just a few
Mrs.
points.
Could-
As it was pointed out,
Hang on.
oh,
Could you just turn the mic? Someone texted me and said people are speaking like over the mic.
Yeah.
So if
never
you
even
could just-
spoken into a mic
Yeah,
ever, so-
thank you.
Yeah, if you just lean
Can you hear
into
me
it.
okay?
Yeah.
Kinda lean
Can you hear me
into
now?
it.
Can you hear me now?
Yeah.
Just want to point out, as you already know, or has been pointed out, she's been developing growing a business from scratch in the last year in a residential area, and which used to be my old home that I grew up in. It's a very, very close neighborhood, and the houses are very close together. And she's been there for, as I said, almost like a year about. And there has not been one complaint from any neighbors in that whole neighborhood. She's exceptionally conscientious about the dogs. The only time the dogs will play in a and make noise in a daycare is if they're initiating play. Most don't bark to initiate play, but some do. And it's very brief. Sometimes we bring them in. If we've got a noisier one, they go inside. It is a full management system. If any of you are in the teaching field and you know anything about classroom management, it's similar to that. It is not sitting with a puppy in your lap all day long. You are out there and you are managing, and all the dogs are different. The weather will affect things, the moon, the temperament, the blend of dogs. I mean, there's a lot to know in managing the dogs. And that's her expertise, and I'm learning it with her. And we take it very seriously. And I think it's a huge endorsement that not one person is called from that very close neighborhood in a whole year, okay? And we actually shared the fence. I mean, it's not good fencing there because it's temporary. We've been looking to go to a properly zoned location for a year, but we end up with problems such as we're having here. But now we're in a properly zoned area, and she could live on the premises and still have a separate, her business, the dog area, separate from her home area, which is critical for a real lifestyle, because she's looking for a real lifestyle, not just taking a bunch of dogs and jamming them together. She wants to keep the business very small, but we need the flexibility to be able to have a higher maximum, because the bread and butter comes during vacation times. Boarding is the moneymaker, but we don't really enjoy the boarding as much, but that is the moneymaker, and that is a chronic need. So for short periods of time, you're going to have more dogs. And depending if they're cratable dogs, a lot of dogs are very happy being crated. So if they're cratable dogs, then you have one set of blend where you do crate and rotate. So you'll have dogs in, watched, there's two of us, then they swap out, in and out, in and out. It's not to anybody's advantage to squish our outdoor space. We purposely looked at this property because it has a good outdoor space. We weren't looking at any that did not. The more space, the happier the dogs, the less chance of fights because they're not in each other's physical space as much. The bathroom, there's so much talk about the bathroom. That is really a moot issue. It's cleaned up immediately. There is no smell. There's never been any smell where we've been operating from. You know what I mean? Your best filtration system is Mother Nature. That's what septic systems are. You send it into the ground. That's the best thing. We do have turf lined up, but we can't make promises at this moment, but I have a lot of turf in my backyard right now, so I got a good deal. But because we are running into the winter time now, we're running into a lot of problems getting our fencing. The ground is now frozen, and we can't put protectant on the wooden fence to keep it from urine on it, because we're getting so late into the season because of these delays. And we just really want to do it right, but now the ground is, we're running into problems. So I just want to stress that she wants to put together a model business, a small business, and ones that you're going to be seeing so many more of in the future. In the 80s, when we went from one-income families to two-income families, we needed daycares everywhere. When I worked at Wang Laboratories, they had a child daycare center in the facility, and you see child daycare centers in a lot of facilities now, and you see mom-pop places. This is where the dogs system thing is going as well. A lot of companies let people bring their dogs to work. Allie lives in a dog-friendly apartment complex, so all those people have dogs there, but they have no place to put their dogs when they go to work. We need little places around, and hers, I assure you, will be a model place. But I do beg you not to put too many constraints on hours of operation. You can't be doing 9 o'clock to 4 o'clock. That doesn't work for any working person, okay? But drop-off and pickups are very fast. It's like an ATM. I mean, you got one or two, parking spaces for ATMs, right? And how many people, 1,000 people do they service a day? People are in and people are out. These people are going to work. They want to drop their dog and get out, and then they want to get their dog and get out and go home. So the drop-off and pickup is not an issue, but we need hours of operation. I just ask, as long as we abide by noise ordinances and smell ordinances and light ordinances and all the different type of ordinances there are, please let us, do the business and show you that it can be done and be done well. This here, I have here, this is just more to make a point, but on October 16th, it took me 4 hours, and I ended up going with it. I only went as far as a quarter of a mile or a half mile. But anyway, these are signatures. Out of curiosity, I just went to all the local businesses local to One Hardy Street. So I went over to the bicycle place, Good Dale's, and I went literally across the street to the dentist area right there on Hardy Street on the corner of Hardy and Broad, and that whole vicinity. And within 4 hours, I got 25 signatures from people who own dogs and work within a quarter mile of that facility, and said they would really benefit and love there to be a facility nearby. And they all equally complained that there are just not enough places. Also, I forget how many I got. It was how many? Like 1, 2, 3, 4, 5, 6, 7, 8. I don't know, maybe 8 8 licensed daycare places. Chewy's owns 2 of them. Well, Chewy's has already said that both of theirs, they are full and do not take more dogs. Okay, so they're not going to take any more dogs. And then I didn't bring in my other numbers. It was a humongous number. Anyway, because I wasn't planning on speaking, but I called up to find out how many dog licenses were issued, and it was, I don't know how many it was. How many? 10,000 in a 6-month period, dog licenses in the last 6 months, or I forget which 6 months. And 10,000. And these daycares that exist right now, they can service anywhere from, 60 to a couple hundred maybe, and that's it. That's it. I know Chewy's, no, it was Pupville. Pupville said that they had a party, Halloween party, and they had 60 dogs that day. And that's a 1,500 square foot place, and they had 60 dogs. Now, I don't know if they have 60 dogs every day, but it was on their website, and they are very full. If you go and look at their page, you'll see wall-to-wall dogs. They look like they have everything under control, so I'm not dissing it. People seem to like it fine. That's not the model that we're looking for at all, because that's more of a, it's not, you're not connecting with the dogs as much. We plan to charge more, have fewer dogs, have a better ratio, because it's more for us. It's not, the big money maker of all time. So that's all I have to say.
Okay,
Thank you for hearing me.
thanks. Anybody else wishing to speak in favor of the plan? With the app? The applicant have any?
Yeah, I would like to address a number of the items that were raised. There's always been this presentation that there's going to be, all these barking dogs, but I think the evidence speaks for itself. We've been before the zoning board, we've been before this board a couple of times. We've had people near Ms. Bird's existing business that have complimented her on the way she operates, and there has been no evidence of any complaints in the area of the business. But more importantly, or not more importantly, but certainly a very important point is that it's a permitted use here. And I want to touch on there was, the information wasn't presented correctly. The attorney that represented one of the appeals actually said in their letter that this ordinance should not be applied, meaning the permanent outdoor display area. And, the abutter, for some reason, was referring to their letter in a different context. But it says right in their letter, 19052 is listed permanent outdoor display areas. Subsection A of the section provides as follows. Outdoor display of retail goods, wares, and merchandise is a permitted accessory use. And it lists the districts that it is, if expressly permitted pursuant to a site plan. No such outdoors display is permitted unless the site plan shows the location, area, and boundaries of the outdoor display. He goes on to say this section is inapplicable to a dog daycare, and then goes on to say that dogs are not a good, a ware, or a merchandise. Well, thank you very much, because that's exactly what the zoning board determined on October 12th. So the zoning board agreed with this appealant's letter. And the zoning board said, just don't want there to be any confusion, and I know the board has this letter in front of them, but the board denied the rehearing request because they did not believe that the code section 19052 for outdoor storage was proper and that the dog daycare shouldn't have been reviewed under this section. Should have gone straight to the planning board. Now, obviously, there's a site plan review process here that we go through, but this section does not apply because dogs are not a good, ware, or merchandise. We're not selling any dogs. As we presented to the zoning board, it's an essential part of a permitted use in the zone. How do you have a dog daycare and not allow them outside? You can't. It's an essential part of a permitted use in the zone. So I just wanted to touch on that real quick, real briefly. The assumption that there's going to be a lot of noise and, there's been mention of decibels and typically, I have 3 dogs, okay? They bark when people aren't giving them attention and are not with them. Part of Allie's business model, or Miss Bird's business model, is to have people there with the dogs, her with the dogs. It was presented that she currently, I believe, watches 9 dogs. When dogs have somebody with them, they are typically content and there are no issues. I think what everybody refers to is like a kennel situation where you're putting dogs in an enclosure and walking away. Well, guess what? They want attention. That's not what we're proposing. So the presumption that this is going to be a noisy site, I think is absolutely a mischaracterization. Just to speak to that on a bigger level, let's assume there is some noise. We have Amherst Street right here. We also have streets on both sides of the site. What does that mean? Well, it just so happens to mean that there is a significant distance between our site and a neighboring use. We meet the setback requirements. Well, actually, there is no setback requirements for the outdoor space. Just touch on noise again. The owner of the building has shared with us that in, I think it was 1958, that building was insulated to a high level because they ran machines inside the building. So we will take benefit of those improvements that were done to that building. The glass, plate glass, it's my understanding that faces Hardy Street, faces the parking area. It certainly doesn't face the abutter that's raising concern over there being a piece of glass, a plate glass. I just don't see any issues here with any of the site plan requirements. We've made submissions to the health department, the engineering department, the, obviously fire and police, and we've gone through a pretty significant review with the community development office. They haven't raised any issues with any of the regulations. The engineering office issued a letter. They want to see some details on how the fence posts are going to be installed. We have no issues providing that. We have no objections to any of the staff recommendations and comments. Just want to touch on the deed and the 2-foot strip situation because I think it can be taken out of context really easy. We do a lot of land surveying work and a lot of work as it relates to right-of-ways and a lot of work as it relates to private right-of-ways that a neighborhood petitions a city or a town to take over. The gentleman's deed, the abutting deeds do reference a 2-foot strip, but that was written when the property originated, when it was a private road. And oftentimes, descriptions in a deed will get carried forward. And we've seen errors carry forward for 60, 70 years or longer. It happens. So the point is that saying that it's in the deed doesn't mean anything because there was a change in ownership of the road that's in between these two properties. And when the city took the road over, there is a chance, 50-50, I would say it's actually higher than 50-50, that the city absorbed that land and took it into the right-of-way. That's typically what a city or a municipality would do in that instance because they want to own the area that they're going to be putting snow, if at all possible, or the area where there's utilities, if at all possible. Unfortunately, the city couldn't provide that data to us. The municipality should have that record on file at their engineering or surveying office, and they couldn't provide that to us. I'm not saying they didn't try. They actually, the city surveyor worked really hard and was very helpful in the process. The reason why it's not important is because it doesn't have an impact on what we're proposing. We're not claiming the land. We're not looking to do something on the land. We're okay leaving it just the way it is. And if the city wants to find out whether they own that strip or not, they can. But to say that it's in the deed and therefore there's proof, there was a change when that property got taken over by the city. There was an opportunity for that to be absorbed, and we can't find that data. Now, with that said, we don't rely on tax maps and GIS information. Yes, neither of those maps reference the 2-foot swath or show a tax map parcel. But none of the utility maps show this swath on it. You know, there's utilities that go up Amherst Terrace. None of those utility maps show the swath. I have them here if the board would like to see them. I just don't think that is really pertinent to, you know, the discussion anymore. And I think that city staff has agreed with us because there's no setback issues. You know, we've gone through the land use code. We've applied all of the regulations that are pertinent to this project. You know, just touching on the WYSIWASH material, and I mean, I did some research into that too. It's biodegradable and environmentally friendly. And it's the same chemical that Chewy's uses. And it's the same chemical that they shared with the board when they went through a site plan review process and this board approved. We felt it was important to utilize the same materials because obviously there was some comfort in that particular product at that time. And it does appear as though that will, you know, service this project well. You know, I think, you know, Ally's mom Colleen did a nice job, you know, kind of giving an explanation of the business. I will say for the record, to my knowledge, there's never been any limitations put on any similar uses. But they have shared openly with you, you know, their business plan for this site and what they plan on doing here. Now, the city shows this as one tax map parcel, or one tax map. I do believe there are 2 parcels of land described here. If we, you know, the client would be, you know, I think we meet all the regulations here. As it pertains to, you know, the setbacks and everything. And that's represented, you know, on the plan, and that's gone through many reviews, you know, through the city department. So I just want to reiterate that we do meet all the regulations. We meet all the parking requirements. We've put together the appropriate studies, and we hope that the board will, you know, act favorably on the application this evening.
Okay. Questions on the applicant's rebuttal from the board? Mr. Bollinger?
Just one, Mr. Chair. One of the stipulations, condition number 6, any work within the right-of-way shall require a financial guarantee. I know that's probably typically a boilerplate requirement, but you have no issues with regard to agreeing to that, given the fact that there is potentially no official record of the right-of-way being delineated along that? You'd be willing to comply with that stipulation?
Yeah, we're not proposing any work, you know, off-site. It is just a standard boilerplate requirement, I believe, that we see on all the conditions, but we're not proposing any work off the property.
Thank you.
Yep.
Further questions for the applicant during this rebuttal? No? Okay.
Thank you.
All right, thanks. All right, at this time, we do have the opportunity, if there's anybody has further questions, I'll allow one more person to come up. And again, I try to keep your remarks to the rebuttal information and not restate previous information.
Okay, well, I mean, you let the lady speaking in support talk about whatever she wanted, so I didn't hear anything about zoning requirements and any of that, and so I'm trying to respect what you're saying and discuss the zoning requirements.
Appreciate that.
So, yeah.
Go ahead and just state your name and address.
Oh, I'm sorry, Clayton Alexander, 1 Amherst Terrace.
Thanks.
Yes, so there are a lot of legal issues here. Mr. Varley, I know you're an attorney. I've worked in the legal field for 20 years, so there's been a lot of misunderstanding in the rebuttal there, and even by the zoning board. Our argument has been, an LB zone permits pet services businesses. The LCBS code says that it's grooming, training, sitting, boarding. And the city required a variance specifically for the outdoor area. So the assumption there is that the outdoor component is not a permitted use and would require a variance. So we agreed with that part, that a variance was necessary, but the zoning administrator was trying to apply this outdoor display area. So what we were arguing was basically that it wasn't applicable. It's true because it has to do with the retail goods and merchandise, but the consequence of that is that the only variance that could be granted would have to be specifically for retail goods and merchandise. That under the law as it exists now, there is no available remedy to seek a variance for an outdoor dog area. So the aldermen, just like they did with the chicken ordinance, the planning department could come before you, propose something to regulate this, and this is a huge problem. There's no regulation on this stuff at all. And so I believe that under the zoning regime, if it's not specifically permitted, it's prohibited. So that's our argument. So as it stands now, under the law, there is nothing specifically permitting these outdoor areas. So we can get into an argument whether under the use matrix, a pet services business includes an outdoor area. There are plenty that don't. Groomers don't, PetSmart don't. There are other dog daycares that do not have outdoor areas, like Salty Claws, I believe. And and again, I think it is just completely inconsistent to apply that ordinance to Chewy's Playland. Make them jump through all the hoops and go through the process, and then the zoning board flagrantly contradicts itself and said, oh well, it's not needed after all. I don't know if any of you are Seinfeld fans, but Seinfeld was a show about nothing. This was a variance about nothing. This has been going on since September, and then all of a sudden, the zoning board says, oh well, it's not needed after all. All of this was discussed. It was a threshold matter that should have been decided from the beginning if that's what they thought. So. As far as the variance itself, it has still been granted. It's kind of this zombie variance, right? It's been granted, it's out there, but now they're saying, well, it wasn't needed after all. So it's still kind of, in the applicant's pocket, but it hasn't been vacated. So we're getting into a lot of complicated legal stuff here. But I would say just at the very least, just based on the precedent that's been established here, that 19052 section has been applied. All of those regulations, I think, are perfectly reasonable. Just looking at the zoning ordinances in general, this isn't an LB zone. These are pedestrian-oriented businesses, which means they are in close proximity, walking distance to residences. There's another ordinance that specifically says part of the criteria for the LB zone. It mentions outdoor waste disposal areas. Then when it's mentioning GB and HB zones, which are specifically mentioned in 19052, it says outdoor display areas. So, I think the presumption here is that an LB business, the only outdoor area that would be allowed in an LB business is for a dumpster, basically, that's, hidden by, it has to be hidden by a fence, shielded and buffered and all of this stuff. So, I think it is perfectly reasonable to ask for some kind of similar regulation of an outdoor dog area. And like I say, it's just, unreasonable that chickens are more regulated than dogs. There's just a whole, host of, health, safety, nuisance issues. And, I guess, my problem here is that, the city has basically been making this up as they go along. There's no clear legal guidance. And I think that the presumption should be, since there's no clear legal guidance, there's nothing clearly under the ordinance permitting these outdoor areas, that they should not be allowed. As far as the deed issues, again, I don't expect you guys to be, the arbiters of deeds. I will just say, when we bought the property.
Definitely.
I'm sorry?
I said we are not, definitely.
Yeah, so, we
won't get into deeds, so.
Yeah, no, I wouldn't expect you to do that. But I mean, frankly, everything that was being said in the rebuttal, again, from a legal standpoint, when we bought the property, my wife worked for one of the for a prominent Lauren Rawson, who's one of the top real estate attorneys in the city. He's deceased now. Told us, that 2-foot strip. When we got into the dispute with Mr. Lanatsis, he admitted that we owned that 2-foot strip. The code enforcement officer that we had come out said that we owned that 2-foot strip. So, I don't think the burden is on me to prove that that's my deed. And, this kind of 50-50 stuff or whatever, I mean, that's.
I think we understand the 2-foot strip confusion, like.
Okay. Yeah, so my bottom line is, something has to be done to regulate this. So just, whatever you can do, please do it.
Okay, thank you. Okay. All right, so, any further questions from the board while we're in the hearing? That being of the applicant or staff? I just have one. For staff, your reading of the permitted uses of this site.
Correct.
Your understanding is that this dog daycare is a permitted use.
Correct. It is a permitted use in the LB zone.
Okay. All right. Anybody else questions in the hearing? No? Okay, at this point,
Mr.
go ahead.
Just one thing, if you do decide to approve the proposal, stipulation number 5 regarding the fire marshal can be deleted. We got an email from him, they're satisfied. And number 4, we received engineering comments, and they're dated October 10th.
Right.
Thank you.
Okay. All right, at this point, I'm going to go ahead and close the hearing and move into the public meeting. Okay, so we have this plan before us. Obviously, it's pretty limited changes to the actual site. We've had probably still remain with some confusion about the sort of ownership of this 2-foot strip that is essentially, under my understanding, in the roadway, which clarifies things for me. So I welcome any comments anybody has or discussions at this point. Mr. Riley?
Yeah, so I would just say, the reason we had tabled this case was to get, clarification on 2 issues that we spent quite a bit of time this evening discussing. And, in my view, we received appropriate clarification. This is, the use that's proposed here is clearly permitted under the use matrix. And, we had asked, the zoning board or the zoning department for clarification on their position. And, notwithstanding any, the procedural issues, I think they've responded pretty clearly, which is, they believe they made a mistake in taking the case in the first place because a variance isn't required because it's a permitted use. And I think that's entirely consistent with, 19052, which, as, both the applicant and the abutter who spoke acknowledged, really doesn't apply to this use. And then in terms of the, the property line issue, I think the applicant made the point, and in my view, it seems correctly, that, absent the application of some sort of setback requirement, it really becomes irrelevant. I mean, it's really, Mr. Chairman, as you indicated, it's really a matter of private property dispute matter that's really beyond the scope of what this board considers. So, in my view, we should, neither of those issues are particularly relevant. We should just consider the site plan on the merits as a permitted use, including the outdoor use, because in my view, there's no indication in the use matrix, or otherwise, that would suggest that there's somehow a limitation on the outdoor use. So that's where I've come out on the two issues on which we asked for clarification.
Other folks? Mr. Peterson?
Along the same lines as Mr. Varley, the abutter, Mr. Alexander, said that he's going to take this to Superior Court. Should we let his future actions affect our decision here tonight?
I don't think they're material at this point with us. I mean, they obviously have the right to do anything they want, so.
Yeah, that's right. I mean,
Yeah.
I would agree with the chairman. I mean, I think, certainly it's within, the abutter's right to appeal the decision of the zoning board, just like they can appeal the decision of this board if they so choose. But I don't think that in and of itself is a basis for determining what action. I mean, we have to take the action we think is appropriate under the ordinances. And if we do that, the affected party always has the right to appeal. But
Okay, I have another thing.
Sure, Mr. Peterson?
On the site plan, on the sidebar, under notes, there's number 18, and I'm wondering if this will affect our board, and it says, prior to any work being conducted, a pre-construction conference shall be held with the planning board, the planning staff, and other city departments as necessary to review work proposed. So are we going to have to look at this again before the applicant finishes their project?
No, that's just the, that's not for us to review, so, yeah.
staff.
That's for staff.
Yeah.
Okay,
That's a
thank you.
pretty
Staff
standard,
would definitely do that.
standard process.
Yeah, but that would generally apply to sort of construction on the site, which is pretty limited. There is some fencing and other things like that.
Right, but
so.
we would typically meet with, if they are going to do any work in the right-of-way,
Yeah.
then we would have engineering there, we'd have fire marshal there, building department. It's an internal review.
It's customized for each project. in a sense.
Okay, yeah. Ms. Arbor?
I just wanted to say that in regards to the mention of the chickens, that I could move in, or anyone could move in next door to someone and have 10 dogs and put down whatever they want in their backyard. And that, this particular business has a great business plan, and that I would rather have this next to me than someone who has 10 dogs sitting out all day outside, not being monitored, so.
All right. Any other comments?
Yeah, I mean, I
Mr.
guess,
Barley? Yep.
I would just say, in terms of the merits, I agree with Ms. Harper. I mean, and also in terms of chickens, I mean, I think most people consider chickens not to be pet animals, but farm animals, and you know, keeping chickens was not a permitted use until the, you know, the recent ordinance change. So I do think there's a distinction, and here we have, you know, pet services clearly being a permitted use, and as the abutter himself acknowledged, that includes, you know, boarding of pets. And I agree as well that the applicant seems to be taking the appropriate precautions, seems to be doing this very thoughtfully. She's got experience at the existing site doing this, so this is not, you know, brand new to her. It sounds like she's given, as I said, a fair amount of thought to this and taken a fair amount of time to pick the location and to think through, you know, the procedures that she's going to have in place and the way in which she's going to manage this. So I guess I would tend to agree that, you know, they will be subject to, you know, all of the ordinances that apply, including noise ordinances, and, you know, if there's a problem, I think that's the appropriate manner for addressing it.
Does anybody have any concerns with the waiver request? It's actually a pretty standard waiver request regarding existing conditions, you know, that go farther out than, you know, Mr. Bollinger?
Only in the sense, Mr. Chair, I think on other waiver requests of similar nature, it's actually stipulated the specific distance within 1,000 feet or 1,500 feet. I can't remember the actual reg
Yeah,
offhand.
it's 1,000. Yeah.
Is it 1,000? Okay.
Yeah, that's in 279E. Yeah, so.
As long as that's covered properly, that's
Yep.
fine. Right.
Okay. Any further discussion?
No.
Anybody willing to make a motion? Mr. Barley?
I'd make a motion to approve old business site plans case number 1. The owner being the Knotz's Family Trust, applicant Ally Bird. Finding that the application does meet the requirements outlined in site plan NRO section 190-146D and section 190-23F, with a total of 5 stipulations. The first stipulation being a waiver request, and that to read is granted will not be contrary to the spirit and intent of the regulations. 2 and 3 to read as written in the staff report. Stipulation number 4 to be amended to read prior to the chair signing the plan, any engineering comments reflected in a letter from engineering dated October 10th shall be addressed to the satisfaction of the engineering department. The original stipulation number 5 being removed, and stipulation number 6 being renumbered as 5 and as written in the staff report.
Okay, so we have a motion to approve of old business case number 1 by Mr. Varley with the stipulations as stated. Do we have a second? Second by Mr. Weber. Any further discussion? All those in favor?
Aye.
Opposed? None. That motion passes.
Merry Christmas!
Okay, moving on with our agenda. So new business conditional special use permits, there are none. New business subdivision plans, there are none. New business site plans. We only have 2 listed, but they're both on a postponement at this point. So with regard to new business site plan number 2, the applicant has requested to postpone until December 5th. And case number 3, that applicant is, I think, recently requested in our packet here to May 21st, 2020. So nothing left on those. Other business, first off, review of tentative agenda to determine the proposals of regional impact. Has anybody had a chance to review this tentative agenda here from the, looks like the November 4th technical review meeting?
I have, Mr. Chair.
Mr. Bollinger?
I believe there are no projects of regional impact.
Okay, so we have a motion to indicate there are no proposals of regional impact. Do we have a second on that?
Second?
Second by Mr. Varley. Any further discussion? All those in favor?
Aye.
Opposed? That motion passes. Okay. Next up, we have other business, case number 2, referral from Planning and Economic and Development Committee on proposed R19-183. So, did you, I mean, I can talk on this because I attended and Alderman Mosey can too, probably.
Yes,
is
I,
there.
actually, Director Marchant and I had talked, and I told her if she was not here this evening.
If you want to go ahead and give the overview of what's going on.
Sure.
Yeah.
So if you tuned in last night, you may have heard our discussion. So please stop me if you've got this. So the resolution is around establishing a committee to draft a master plan. And last night, first I will talk about the amendment. The original resolution called for 7 citizens, and what, in discussing it was decided that each of the wards should have a representative. So it was amended to read 9 residents, 1 from each ward would be a member of this committee. And the discussion that I think Mr. Leclerc and Director Marchant and I and the Economic Development Committee have had is around this being a little different than just master planning for land use. And so the mayor's proposal in presenting this is that the master plan is going to look at a much higher level of how we envision the city moving forward. And I'm going to say 10 years because I think all of you know working with 20-year-old master plan doesn't work for you. So, so I'm going to say for 10 years. But bringing together, you can see the parties that are represented here as the overarching steering committee, but with the understanding that there'll be opportunities for community engagement, and that members of the Planning Board and Zoning and Conservation Commission and other boards and commissions across the city would then participate in, excuse me, subcommittees addressing those areas of interest related to what your purpose is as you work in your volunteer positions with the city. So the city's proposing to hire a consultant. Working with that consultant, a plan and a timeline will be laid out, and we talked about that. People will then be asked to participate, and once that plan and timeline is laid out for how the process is going to work towards developing the final product, we discuss people having a better sense of what their time commitment's going to be in this whole process. And then the vision is that once the master plan is completed, those groups within the city, the planning board being a very important part, will then look at how it impacts what you do. And you will then have this master plan to guide you in looking at our land use codes and making determinations as to how we need to move forward with changing, adding, omitting, whatever, to bring our land use codes into a position so it supports what the vision is for the next 10 years. And I keep saying 10 because I think all of us have felt your pain and have shared your pain. So that's kind of the 2-minute overview and the big picture of what's being looked at. So really looking for support. Comments were made about, like, well, realtors aren't here, and the Board of Realtors, but not someone from the business community. But we have our Business and Industrial Development Authority, so they could be invited to participate. So again, proposed committee is really that overarching committee, but it's not meant to limit participation from other groups. And I think the roles of all of the other boards and commissions, as well as just residents of the city, will be more clearly defined once the consultant is brought on and we look at a process and we start looking at how we're going to go out and seek public input into this process, as well as working with all of you. So Scott, what did I miss?
Yeah, no, I think that covers it pretty well. You know, I think it's important that it, you know, let me just say, I support the establishment of this long-term or long-range planning, you know, group myself. I do think it's important, you know, that the two members of the planning board be presented, and, you know, specifically because you know, this, and there'll be some that'll ask, the city charter, the master plan is the planning board's duty in the city charter, right? So this is sort of, so we need to be in agreement, I think, formally with this resolution, or at least have input to the point that we agree with it and support it. Otherwise, I think there could be some conflict in kind of the whole process, right? You know, and this process isn't that's being proposed. The city has done it this way before, you know, in like kind of the 80s. The last master plan was a different process. So I think if anybody has any issues or concerns with the process, they should bring it up now, and we should talk about it. I don't personally have them. I do think, I mean, I would have an issue if the two planning board members don't make the resolution. I think that would be really in conflict with the city charter.
Right.
Because it'd be very hard for the planning board to meet the requirements of our city charter without being part of it. But with being part of it, it's pretty easy, so.
Right. And-
So I think it makes sense, you know.
Right.
Yeah.
And again, as we discussed last night, there's two members of the planning board, and it was brought up, well, there's only one alderman.
Right.
But again, the vision is that there'll be subcommittees people can participate on, and certainly, once the master plan is completed, the land use piece, which is really what you're all about, will come back to you to work on. So, once this master plan is completed, my vision is that you really get the work, because then all of that comes to you to look at, and alongside the existing land use codes, to make that determination as, well, we want to propose these changes, add this, omit that. We need to do some new things about density of housing or different zoning and what identification of zones. So really, you're going to be, out of all the groups here, I would envision most intimately involved with what happens after this. So you will still have your role in looking at land use codes.
Right, and traditionally, after the master plans, those are gonna get rewritten.
Right,
You know, to be consistent with the new plan.
right.
Or redeveloped and adjusted or what have you, so I think it's important. I mean,
Yeah, I guess I just.
Mr. Varley? Go
Yeah,
ahead,
I have a question about sort of the process. So obviously, this committee is going to draft the master plan, as that's what's contemplated the resolution. Is the expectation, I mean, and I don't know the provision of the charter well enough, but is it, when the master plan that's drafted then comes back to the planning board, is the planning board ultimately responsible for approving the master plan?
The master plan will be approved by the Board of Aldermen, and then, once it's approved, it will come here for you to then,
As would any land use ordinance?
Right,
So it
right.
would be a recommendation?
right,
So the provision of the master plan is then really preparing, it is this part of the process, it's the, formulate a master plan.
Yeah, it's a little weird in the charter. It's almost like the planning board is actually the one submitting it to the alderman. You
Yeah.
know, where you know, so that's why I say we have to be kind of like part of it, you know,
Yeah.
and
Well,
otherwise it'd be hard to do it, so.
Right, and again, I think that, as you look at among your membership, who's going to participate, it's going to be helpful to know from the consultants what the timelines are going to be and what activities will be required for whoever's on this committee. But then again, as we move forward and set up under that process, as subcommittees are set up
Right.
or activities are set up to gather information. And as we talked last night, we may set up quadrant meetings
Yeah, they'll probably
to
do.
meet with residents rather than just doing specific ward meetings. So you may decide, well, people on the planning board who are not these two representatives, we may assign them to go to each of the quadrant meetings. So there will be ways for, I think, everyone to be involved, and I hope everyone would be, because I think it's really important. And I know you, even if you're not at a meeting, you're watching it or reading the minutes, because we all know how important that information is to making our decisions. So, as I said, the same comments were made about the alderman. There's only one alderman on this committee, and it was like, well, how are we going to get input? But I would anticipate aldermen will go to different meetings depending upon the topic or where they're located. So it's certainly not meant to reduce people's involvement, and I believe all of you are committed to this, so I believe that you'll be actively involved. Not whether you're on this master steering committee or not. I would envision all of you being involved.
Mr. Weber?
Yeah.
So, if you're not part of one of the members, is it the other member's ability to change things or just make a recommendation?
Well, the process really hasn't been necessarily.
No, I mean, when it comes back to us.
Oh.
As a group, and throughout, is other members still gonna be able to weigh in and say, well, I think this should be this, and then would that make a change or not?
Yeah, well, I think that in general, kind of like Alderman Zagoya said, we don't have the sort of full process in place, but, you know, I would envision that, yeah, the planning, whoever's, the whole planning board would have input in probably a lot of places.
Yeah.
And in components. And certainly the two members of that are on the long-range committee here, you know, can speak for everybody
Okay.
on the planning board. So internally, how we decide to sort of gather all the planning board input and transmit it into the long-range group is sort of up to us. We can generate however we want to do that, so I think.
Would that be a
yeah.
good, like, from time to time, have a discussion item as to
Yeah.
an report?
Sure.
Do an update.
Yeah, sure, there could be,
Yeah.
there could be
Update.
updates, there could be specific, you know, workshops and meetings, obviously.
Right.
Yeah. But-
And for the smaller, you know, there's, I don't know, like when we did the waterfront development, there were meetings here and there were boards up with pictures and whatever, and anyone could come and have input. So I would envision those sorts of activities happening,
Yeah,
so,
I think that a lot of the board members may want a lot of input
right,
and not be on the board, you know, not be there for the two people, but they still want to really kind of chew on it and say, well, I think this might be
Right.
better, and they have plenty of input without being, well, those only two people are only going to do it, so I think
Right.
that's good.
right.
Yeah, and there's definitely, because there's so many, there's the value in having all these points of view in the total. We, you know, limiting, by putting two planning board members who can capture the entire planning board input, it does make the committee a little more manageable.
Yeah.
You know, it's pretty big already, and, you know,
Yeah.
and I think I'd recommend, there was talk about the quorum
Right,
concept in this, and that, you know, standard quorum percentages may be onerous with
Right.
this size committee, and I guess if if someone was gonna make a recommendation, and generally what we'd be doing with this tonight is making potentially a positive referral with recommendations if we want to. I think it may help the aldermen too, who we're feeling the same way, is kind of what I got out of the meeting.
Yes.
To say that, you may want to reduce the quorum requirement if possible with this group, because trying to get, say, 50% of them there all the time could be a management issue of the size of this committee.
Yes,
So-
I would agree with Scott.
Yeah.
If you're comfortable with saying you would support reducing the quorum from 50% at a number to be determined, we were going to have conversation with Attorney Bolton
Yeah.
and kind of flesh it out. But if you're comfortable with that, if you would like to make that recommendation, or just so we know moving forward, you're okay with that. Because I think all of us have sat at committee meetings where you're like, oh, I'm hoping someone can phone in, or you've been playing dial a friend. So you have a quorum because there's something you really need to do. And just before I forget it, Scott, to your point about getting input and updating your, the planning commission, or the planning board, you may want to just add something to your agenda that says master plan update, and if there's something, you do it, and if there isn't, you don't, and then at least it's like there, and people know it's going to happen, so it may be something moving forward to continue, just so you capture it, and it's always part of what you're doing too, because I do think it's important that you have conversation with the people who are representing you to bring that back.
Right, right.
It can go in our packet.
Yeah, yeah. And I have talked with Director Marchand too about the planning board being involved in the consultant selection.
Yeah.
Because I think that's another place where we would be, at least get input. So
Yeah.
I don't know that that's related to this. It's a different.
Right.
I mean, that's stuff that's being done within community development, right? The RFP and the selection of the. Yeah,
Yes.
that's, so.
Yeah.
So, we can have input into that process, or that selection process as well.
So that hasn't gone out yet, the
No,
RFP?
no, that hasn't, yeah, it's being developed right now, so.
One of the things,
But
I'm
just-
sorry, go ahead.
Just shortly, I mean, I have talked to Director Marchand, and we'll be reviewing that, intend to participate in the consultant selection,
Yeah.
so,
That's key.
yeah. so.
Yes.
One of the things.
Mr.
that,
Weber?
Yes, one of the
Yeah.
things that, within our city is the Nashua Regional Planning Commission, which has
Right.
has made recommendations and has a whole host of knowledge. So it's a good place to reference they've done master plans for other cities, and so they know how this all goes down. So it's a good reference place too.
Yeah, that was brought up, or maybe it was Director Marchand mentioned it to me that, again, I think those are all resources that, they'd make the consultant aware of.
Right.
To kind of roll in, So does anybody have any concerns with the makeup, Mr. Peterson? Yeah.
With regard to the resolution before us, R-19-183, I just have a point of minor clarification.
Sure.
It talks about the Board of Aldermen and the Planning Board, but item number 1 says, members of the Planning Board to be designated by the board chair. So which chair are we talking about? We're talking about the Planning Board chair,
Planning board
correct?
chair.
Yeah,
Okay.
that's a good,
Okay.
good point, so we should
We
recommend.
will, I will recommend that amendment when
Yeah,
this comes
just a
back
quick-
to PEDC.
Yeah. Okay. Or it could be, like it says a little further down, of said board, yeah, yeah, so.
We should know which board, because
Yeah.
the two of them were mentioned.
Yeah, I think that's the intent, but, okay. Any other discussion things, or?
No, I mean,
Mr.
it
Barley?
seems to me like a sort of a reasonable makeup for the board. I mean, it's a good sort of cross-section, from, obviously, sort of members of city government and members of business and members of sort of significant institutions, as well as, substantial representation from residents of the city, so. I agree with you, Chairman. I mean, I think it will provide, diverse viewpoints, which I think is really important in terms of designing the master plan. In terms of the specific quorum issue, I mean, I can see how, quorum could be a challenge. I think you need to be a little bit careful not setting the quorum too low, because then what you have is that great sort of diversity you have, then suddenly it's the same, 6 or 7 people that are at the meeting, and you're sort of excluding that. So I do think part of the process, for selecting these individuals needs to be, the people need to understand that they're making a commitment to be a part of the process, and that they're expected to generally attend meetings. Now, obviously, with 21 members, you'll have, some leeway there that not everyone needs to be there all the time. But I guess that would be my only caveat on the quorum, would be you need to be careful not to make it too low so that you sort of end up eliminating participation by sections of the committee by default.
And I would agree with you. That would be my concern, because I think we want a balance of residents as represented by the 9 members, 1 from each ward, as well as all of the other different areas, businesses, the health community, the realtors. We need that richness to have good decisions. So
Yeah.
I would agree with you.
Do you think that the last 2, now that we've sort of, or that it was suggested to have the 9 members, 9 residents, 1 from each ward, is the chair below and that like kind of repetitive? Could that be? Because that person's gonna be one of those.
It's going to be a resident of the ward.
I
Well,
mean, I don't know.
and I mean, it
People were
actually,
concerned about the size, so I was
Yeah.
like, is that the same person? Yeah.
part of our discussion last night was 9 residents, not citizens, because a citizen of Nashua could be construed to be a business person.
Correct, yeah,
So
right.
either way, and I think that, it's kind of like when I'm on the Board of Aldermen, I'm representing Ward 8, but I'm really doing, it. When you look at the percentage of what I've encountered in 10 years
Yeah,
as being Ward 8 specific, you're really there for the host city.
Yeah.
So I think regardless of whether the person is a resident or a business owner, citizen, you've got like a bigger perspective that you have to do that job. And so I think it would almost make the chair's position more difficult if you were representing a ward and trying to chair the committee.
good point, yeah.
I think, especially because, as you heard in the conversation last night, the real goal in terms of having those residents, 1 in each ward, is to use them as point people to get involvement from those wards. So if you're trying to do that and you're trying to manage the whole committee, it could get a bit overwhelming, and something's going to lose out.
Yeah, those are good points, I agree. Any other thoughts, questions, comments? No? Mr. Weber?
As you said, at the end of the 10 years, is there going to be wording that they're kind of like, would it be just, this must be reviewed in 10 years, or it could be reviewed in 10 years?
I think that's something that will have to be decided.
Okay, that does not be
Part of-
decided today.
No, this is just to say who we think the members of the committee will represent.
Okay.
Who are the groups that are going to form that umbrella committee.
Okay.
And all of those other things will be determined as the plan is developed and things are put in place.
Okay, great.
Yeah, yeah, because with that comes a funding issue, as we all know, which is what's held us up in getting to where we are today, so, yeah. Any
Okay.
other thoughts?
Anybody willing to make a motion on a recommendation? Mr. Varley?
I'd make a motion to make a favorable recommendation on R-19-183 as amended, to establish a committee to draft a master plan, and simply suggest that, you know, the Board of Aldermen take into account the particular issues that we've discussed in making the favorable recommendation.
Okay, so we have a motion,
Second.
we have a motion to provide a favorable recommendation of R-19-183 by Mr. Varley,
Second.
second by Mr. Weber. Any further discussion? All those in favor? Aye. Opposed? None? That motion passes. Thanks.
Thank you.
Okay.
And the Board of Aldermen looks forward to your continued participation.
Okay, so any further discussion items? No? Okay, at this, Alderman Malloy,
Yes,
go ahead.
just, I saw the memo around
Oh,
the
yeah.
pedestrian bicycle plan.
Oh, yeah.
And last night, I sit on the executive committee for NRPC, and last night, in just checking through projects and where they are, they have started working on our pedestrian bicycle study. So
Great,
just to let you know that that's moving forward.
excellent.
Yes.
Okay. Any further discussion items? No? All right, anybody want to make a motion to adjourn?
So moved.
We have a motion to adjourn by Mr. Peterson. All those in favor?
Aye.
Aye. That motion passes. We are adjourned at 8:52.